This is estate planning lawyer Michael Pevney, and in this video we're going to talk about where do you keep your estate plan. But before that, if you've got any questions related to estate planning, please subscribe to this page for more estate planning information, and you can ask a question in the comments section. I'm usually able to get back to most of them. So at the end of the estate planning process, and when we're doing a signing and everything's getting notarized, it's time to start talking about where to keep an estate plan, because most of the plans that I create revolve around the central document, which is the trust. Typically a revocable living trust if it's a family that has kids that might own a home that has under maybe $10 million in assets or so. So the question becomes, what do we do with this thing? Like, we got to file it somewhere. Where does it go? The answer is, for a trust is a private document. So you actually don't have to file it anywhere. And that's one of the great benefits of a trust, is it is totally private. It never has to go through the court system. It never has to go through this complete asset distribution system that's run by the government and run by the courts called probate. We really want to avoid probate because it's expensive and it's time consuming and it's just a pain. So a trust, you have to keep the document. So the question becomes, where do we store this document? I do not keep the documents for my clients because they might need them in a pinch, because a complete estate plan includes lots of other documents like a financial power of attorney or like an Advance Healthcare Directive. And guess what? My law office isn't open 24 hours a day, and someone gets in a car crash or a car wreck and they're in the hospital and we need to get that Advance Healthcare Directive to them. That's not going to happen in the middle of the night. This is why it's important that clients, that people have control of and know where to keep these documents. One place to not keep them is a bank safe deposit box. We do not store estate plans in a bank safe deposit box, because a safe deposit box is not really a bank account that has signers on it like a joint account. It's really more of a lease. You're actually like leasing that little box in there. And if you're missing a key and if your name isn't on that lease, it's going to be very difficult to get in there, especially when there's some kind of a medical emergency and we might need to get to those documents quickly. And by the way, you know, when people talk about banker's hours, they're talking about a place that's not open very often. You know, a bank is open maybe 20-25% of the hours of the week. So we want to keep that stuff out of a bank safe deposit box. Another reason we don't want this stuff in a bank safe deposit box is because that might trigger us having to go through probate, right? So let's say your parents pass away, you know they have a trust, but you don't know where it is, or you know that it's in a bank safe deposit box, but there's no copies of it. And you don't have a copy of it, and there's not a Xerox of it, there's not a digital file containing the document anywhere, and you can't get into that box. So how do we start administering the trust? The only way to really do that is you have to end up going to probate, which completely defeats the purpose of the whole thing. You've got to get into probate court. You might have to get these special letters from a judge called letters testamentary, and then you might have to deal with the bank because your name isn't on that safe deposit box. You're going to have to get death certificates, you're going to have to go through court, and you might have to deal with the bank's lawyers because someone is going to have to go in there and drill into this thing to get these documents. And then finally, maybe you can, I guess, somehow stop the probate, but this can take months and months and months of completely unwanted and unnecessary hassle just because something was stored in a safe deposit box. So this is what I recommend for my clients. You want to keep the stuff somewhere that's safe but not too safe. Frankly, I keep my estate plan, it's in the bedroom closet, it's on an upper shelf. Everybody that needs to know where these documents are, meaning my successor trustees, the people that are going to take over, my powers of attorney, the people that need to take over, they know where it is and they know how to get it. You can keep it in a safe. If it's in a safe, the essential pieces, the people that need to be involved with your estate plan, they need to know where they are. I also give my clients a digital copy. So after everything is signed and notarized, I scan everything. And I give my clients a digital copy and I tell them the next trustee or your powers of attorney, they should have a digital copy of this because oftentimes a digital copy can be good enough, depending on the institution that you're dealing with. And then I, of course, always retain a digital copy of the documents. I do not keep the originals because you might need the originals in a pinch. So, bottom line, when it comes to an estate plan, where to keep it, do not put it in a safe deposit box. Keep it somewhere safe, but not too safe. Make sure there are digital copies of it and that everybody who is essential to your estate plan knows where the originals are and probably has access to a digital copy. If you have questions about this or anything else related to estate planning, you can set up a time to meet with me for free by going to ocestateplanlawyer.com. The link is in the description. Subscribe to this page for more estate planning information, and thanks for watching.